Welcome to Be Bold America. I'm your host, Jill Cody, along with my co-host, Dr. Pettis Perry. How are you today, Pettis?
I'm doing really well, my friend, up here in the sweltering Pacific Northwest, which I don't get to say to you often.
No, you don't. Well, I'm calling from home because yesterday my husband, my hero hubby, was diagnosed with COVID.
Oh, no.
I'm not in the studio, and I'm missing everybody. And I'm also hoping I'll get through this topic. It is such a personal issue for me because I lost a girlfriend in high school to a back alley abortion. I went to high school before Roe v. Wade, and so it's very emotional for me. So I'm hoping I make it through without choking up.
Well, that's okay if you do choke up. I'm here to support you, and I got you.
Oh, you're so wonderful. And we have a wonderful guest today, too. Our program today is Dobbs v. Jackson, a cascade of consequences. Women, did you just wake up and realize the Supreme Court stole your body? What was the constitutional reasoning to overturn Roe v. Wade after half a century? What was the Dobbs v. Jackson lawsuit all about? What did the concurrence and dissent opinions say? What is stare decisis anyway, and how is it used to cause judicial continuity? Justice Clarence Thomas stated that other cases should be revisited. What does that mean? Did he or other justices mislead the Senate and the public at their confirmation hearings? Our guest today will answer these questions and more. We all, men and women alike, must understand the cascade of consequences from this astounding reversal of women's rights. An American legal scholar who is a university professor emeritus at Harvard University, Lawrence Tribe, stated, if the right of a woman to decide whether to have a baby won't qualify as a guaranteed right, then neither will most of the rights you have long assumed are yours. We have big things to do. Pettis, would you like to introduce our bold guest today?
I will, and I think we have a very important topic, and I'm so happy she's joining us. Today's guest, Professor Margaret Russell, is an associate professor of law and has been on the Santa Clara University School of Law faculty since 1990. Professor Russell specializes in civil procedure, constitutional law, and contemporary legal theory. Professor Russell is affiliated with the university's Center for Social Justice and Public Service, the Markula Center for Applied Ethics, and she is also affiliated with the Center for Multicultural Learning. She has been honored for her contributions to student life by the Asian Pacific Law Students Association and the Black Law Students Association at Santa Clara University. Prior to joining the Santa Clara Law faculty, Professor Russell was a fellow at the public interest firm Public Advocates, Inc. She also served as the Director of Public Interest Programs and as the Acting Assistant Dean of Student Affairs at Stanford University. It is with this great pleasure that I introduce Professor Russell. Welcome to Be Bold America.
Thank you very much for having me. I'm looking forward to this discussion.
We are too. Jill,
we
back to you.
We are too, yes. Yes, we're looking forward to it. Professor Russell, thank you for joining us today. You know, Pettis and I thought it would be essential to have you as an interview guest at a time when we're all attempting to figure out just what happened at the extreme Supreme Court. It is sadly an historic moment that is necessary to understand. And before we talk about the cascade of consequences, I did want to, before we jump into the heart of the topic, there is a question that I wanted to ask that is on the minds of broadcasters around the country, and to give it a minute or so. You know, if a broadcast journalist produces a show that offers abortion access resources or that advances or advocates for abortion rights, could that journalist experience consequences in states with anti-abortion laws? Further, it seems to follow that if you take the anti-abortion stance, they literally view abortion as murder. Therefore, if broadcasters provide information supportive of an abortion, could they be seen in those states as aiding and abetting murder? What are your thoughts about journalism and this decision, Professor?
Well, I think that this is a very important time for us to recognize our free speech rights under the Constitution, and we do still have them. And I would use as an example the comment at the very beginning of this program distinguishing the viewpoints expressed during programs by journalists and guests and any official statement of the station itself. So my answer to this question would be that it should not be seen as any kind of violation of a law to have any of us exercising our First Amendment free speech rights to give our opinions and to discuss and persuade, and it certainly shouldn't be seen as aiding and abetting.
Thank you for that. That's reassuring. In California, we're very comfortable with that, but, some broadcasters in the 26 states that are dealing with this issue of really criminalizing abortion, it was a kind of a scary future they were looking at. But that's an excellent point. Thank you. And also, just to start, too, tell us what was the Dobbs versus Jackson lawsuit, and what was the Supreme Court's constitutional reasoning behind it?
Yes, certainly. So I will note at the beginning, as many of you probably suspect, that the Dobbs versus Jackson case was pretty carefully planned by people who wanted to find a case to reach the U.S. Supreme Court in its relatively new conservative posture. They wanted to reach this court to give them a chance to overrule Roe versus Wade. Roe versus Wade, as you know, has been around since 1973 with a very different set of justices on the court who agreed nevertheless that, at least a majority did, that there is a liberty interest, there is a due process interest that women have under the Constitution. There's a right to privacy, and that restrictions on abortion are restrictions on that right and therefore have to be scrutinized very carefully. So that was 1973, and ever since then, there's been an ever-escalating political movement, joined by various religions and organizing, and it's all been with the intent to overrule Roe versus Wade and to ban abortions, essentially. So that brings us to cases between Roe and now. The most important one I would mention is the Planned Parenthood versus Casey case, which was overruled in Dobbs this year as well. And in Planned Parenthood versus Casey, the state of Pennsylvania had placed restrictions on a woman's right to choose, very commonly imposed restrictions by states, which had sometimes a waiting period, mandatory counseling, parental permission if you were a minor, et cetera. But that case happened in 1992, and the people who were pushing that case to the Supreme Court really wanted Roe versus Wade to be overturned, and they thought they had a chance. However, some Republican-appointed justices joined with the liberals and said, the important thing is not whether we would have decided Roe this way to begin with. The important thing is that a generation of women have relied upon it, that it is a recognized right, and we can't just take that away because of the value of precedent. So, sigh of relief on the part of pro-choice people, determined, digging in and trying harder. And this is where changing the makeup of the Supreme Court really made all the difference. And for those who just remembered, the last three justices on the court through Donald Trump, some of them like one of them I call a stolen seat, because Neil Gorsuch's really was during the Obama administration, and then the other two, Brett Kavanaugh and Amy Coney Barrett, that really solidified enough justices to join with at least the conservatives Samuel Alito and Clarence Thomas to overrule Roe. And even before we get into sort of the facts of it, I think it's very important to see that kind of institutional manipulation going on. So now there's a really conservative court. The Dobbs case comes from Mississippi. A Mississippi law is banning abortions. It's a very strict banning of abortions after 15 weeks, which is a clear and direct violation of Roe. And it was purposefully passed as one of other laws that could go up to the Supreme Court. So now you have a conservative court. You have 6 justices who say that the law is valid, that kind of ban can stay. 5 of those 6 say that Roe versus Wade and Planned Parenthood versus Casey are overruled because there is no constitutional right to privacy or liberty in this context, and that includes an abortion. Chief Justice Roberts, interestingly, he voted with the majority to allow that Mississippi restriction to stay, but he wrote separately because he actually thought, as other conservative justices in the middle have thought, that maybe he wouldn't have voted that way in Roe. He certainly wouldn't have, but the consequences are enormous. So, that is kind of in a nutshell how the case of Dobbs got to be decided by the court in the way it is this year.
Well, we have just maybe 2 minutes before our first break. Can you just explain what stare decisis is?
Yeah, stare decisis is, other than being one of those Latin phrases that make law sound so mystifying, essentially it refers to the decision stands, to let the decision stand. And it is a long-used doctrine in court decisions that respects the role of precedent in creating a stability in the legal system. And so stare decisis essentially means let previous law stand unless there is a compelling reason to upend it. And despite what they said at their confirmation hearings, several of the most recent justices clearly thought there was a compelling reason to overturn Roe, and I'm sure they thought it when they were testifying. So in their view, stare decisis didn't apply because it was egregiously wrong to say that women had a constitutional right to choose.
Well, it seems very important when you have decade after decade after decade of people coming and going off the court after 240-some years, that precedence would be very important. So you have that continuity in law and throughout society. So this is just doubles the shock. You are listening to Be Bold America on KSQD 90. Many voices, one station. Listen globally online from the KSQD.org website. Our topic today is Dobbs v. Jackson, a cascade of consequences. And we're speaking with Santa Clara University School of Law professor Margaret Russell, who is explaining for us the constitutional reasoning behind overturning the rights of women that were vested to them in the Roe v. Wade decision 50 years ago. I'm your host, Jill Cody.
Hello, K-Squid listeners. I'm Tom Hartman, and each weekday at 4 p.m., I bring you a different perspective on the news than you're likely to hear on most media outlets. Please join me on KSQD Santa Cruz, your ink spot on the dial for the Tom Hartman program, heard now for the first time ever in the Monterey Bay area at 90.7 FM, weekdays at 4 p.m. That's progressive talking conversation with me, Tom Hartman, weekdays at 4 p.m. on KSQD 90.7 FM. Tag, you're it.
We're back, and we are speaking with our bold guest, Santa Clara University law professor Margaret Russell, who specializes in civil procedure, constitutional law, and contemporary legal theory. Pettis, I don't want to leave you out of this conversation. I know you have a question.
I don't feel left out, my friend.
Oh, good.
I'm wondering what the basis for their decision was. What gives the Supreme Court the right, other than their position, to determine what a person can do with their body in the sense of abortion? What was so, other than religious preferences, what was so important to get this overturned?
So that's a great question, and some people do think that the individual religious belief system justice has had something to do with it. However, their justification in saying there is no right to privacy or liberty or abortion in this context was by beginning the discussion by saying the Constitution does not mention abortion, which is, it's such a patently ridiculous, frankly, way of introducing a complex subject, because there are many words that are not in the Constitution. There are, AR-15, and just because it's not in the Constitution doesn't mean that it doesn't involve a right that is in the Constitution. So the lead opinion that was agreed upon by 5 people, and Justice Alito wrote it. And by the way, it's very similar, very, very similar to the draft that was leaked earlier, mysteriously. But his explanation is that a constitutional right has to be deeply rooted in this nation's history. And and then he goes through a historical discussion of abortion prohibitions in the different states, even going back to English common law. I am not a trained historian, but historians who have read it said that it is a extremely tilted manipulation of a very complex subject of history. But his conclusion is this is not deeply rooted in history, and it's just made up. Essentially, they're saying this is a made-up right. It never existed, and so we're just going to correct the mistake.
So what does this mean for everything else that's been decided that might fall in that same bucket? Are they trying to undermine the 14th Amendment and to do away with all rights that were deemed afforded to citizens? Or where does this go from here?
Well, the door is open, and I would say wide open, because of Clarence Thomas's concurring opinion, which he really went out of his way, since he agreed with the majority. He went out of his way to write separately to state that he thinks that the lack of reasoning under Roe and abortion, he thinks that also applies to other rights. And he cites a couple of cases. One case has to do, kind of shockingly, with a 1960s case that recognized a right for a married couple to get contraception, right? So that same right to privacy, that zone of decisions that you make in your personal life, Clarence Thomas is saying, no, that edifice is not strong. He also mentions same-sex marriage and the Obergefell decision, which is very recent, but he's suggesting that is a made-up right, the right, freedom to marry of people of the same gender. Others have brought up right to marriage in terms of interracial marriages. Now, he didn't mention that, but it's actually a very similar criticism that might lodge. Right, of course. Yeah. Although I had a thought the other day, this is digressing just a little bit,
Sure.
Even though Clarence Thomas is in an interracial marriage, I mean, think of the race hatred that we've learned about so much around January 6th and beforehand, and people who believe in the so-called replacement theory, which is this country is getting less and less white, and we have to do something about it. So that kind of hatred and fear is exactly why there were bans on interracial marriage. And it seems as though we're cycling back to that. So you were asking, does this threaten other rights? You know, the majority says in their opinion, this is just about abortion. We're not saying anything about any other rights. But Thomas, who really, I mean, he has now become extremely influential on the court. He's just been on the court longest period of time, waiting, extreme views, slowly sees those views pushed from the right to the center. By saying what he did, he very deliberately suggested that cases that would challenge those earlier precedents that all have to do with personal decisions, family decisions, they are up for grabs.
Professor Russell, did Justice Thomas and the other justices mislead the Senate and the public at their confirmation hearings?
Well, I don't know. I mean, I'm old enough to remember when Clarence Thomas, the hearing occurred. It was actually my first year of teaching. I don't know if you saw it. And that that hearing was very much dominated by the allegations of Anita Hill. But before that, I distinctly remember Clarence Thomas being asked about his views on Roe versus Wade. Right? So this issue, as I mentioned, has been around for a long time. And I recall that he said he never had any particular opinion, or even though he was in law school at the time, he doesn't remember having any discussions. And when he was pressed on it, he said, you know, I see my job as just being stripped down like a runner. You know, I'm a blank slate, and I'm not approaching this court with any agenda. You know, is that lying under oath? Well, that in itself wouldn't be a provable case, but let's think about the number of times that Roe versus Wade came up before Alito in his hearings, Kavanaugh. I mean, the reason why Roe versus Wade and the Latin phrase stare decisis came up so often was because senators really were suspicious that the court was being stocked with people who were quite willing to overturn precedent. And, in fact, they were right.
Well, it seemed very obvious to the rest of us. We weren't in Congress, but it seemed very obvious it was being stacked. Pettis, you had a question?
Yeah, this whole line of discussion, I guess, really has me thinking about the extent to which personal belief systems impact decisions. I mean, I've been an executive leader, and I know that I've had to weigh decisions that involve my personal feelings versus what I thought was right based on the policies and procedures. And I've always tried to be neutral in my own position and see the case before me as best I could from a neutral perspective. And I always thought about judges being those kind of people. But what I'm seeing with the Supreme Court is whatever personal belief systems they have are no longer being sheltered. If you really look at what they do and how they function, they're really telling you what their beliefs are, and now you see them acting on those beliefs. So it's not just the absolute decisions that are being made, but the thinking and the processes and the foretelling of what this could lead to based on what's in the public domain, if that makes sense. What are your thoughts?
Well, that posture of being judicious, of being neutral and fair, is so important in a range of contexts, and most especially as a judge, because as Ketanji Brown Jackson said when she was questioned in her Supreme Court nomination hearing, she said, I approached this job without fear or favor. My purpose is to apply the Constitution, apply the law. And the reason why we have 9 justices now, multiple justices, is because a range of views is important, but each of those views should be as dispassionate and fair and nonpartisan as possible. So that's why I think the whole issue of the stacking of the Supreme Court, essentially through the last administration, has caused a lot of disillusionment among the American people, because now they are thinking that the Supreme Court is just another political branch.
We're coming up to a break again, but I wanted to get back to Alito's opinion again, because I don't remember the specifics, but I think people really need to know how far back he reached. Wasn't there some 16th or 15th century witch hunter, or that he...
Oh,
yeah,
absolutely. I mean, it was pre-Constitution, and it was without regard, and this is really important, really, in any constitutional discussion you have, without regard of the fact that something that is rooted in history and tradition may be manifestly unfair and may have been completely changed by the progress of the United States. For example, slavery. For example, women, witch hunts. For example, women having absolutely no power in society. And so to discuss history and tradition as though it is this salutary, dream that we always have to think about, well, none of the voices on this call were part of that. We weren't part of that history and tradition.
Well, it also seems to be a subliminal, or maybe not so subliminal, message to women when you're citing a 16th century witch hunter, that to tell us you have no power again. I'm putting this in my legal brief, my legal decision. You don't have any power. Well, time for our break. If you're just joining us, our topic is Dobbs v. Jackson, a cascade of consequences, and we're speaking with Professor Margaret Russell from the Santa Clara University School of Law. Pettis and I would like to add you to our news group, and you may do so by texting Be Bold America at 22828. Text Be Bold America at 22828. Thank you for signing up. We'd like to see our list growing. We'll be right back with our bold guest, Professor Margaret Russell, right after Jim Hightower explains how a cabal of right-wing zealots installed a 6-judge majority onto the Supreme Court to steal a human right in his commentary titled, An Angry Public Will Overcome Arrogant Officials. I'm your host, Jill Cody.
Donald Trump's criminal attempt to steal the 2020 election failed, but it's not the only recent coup attack on our democracy. In the last few years, a cabal of right-wing zealots have plotted to seize control of the U.S. Supreme Court. By hook and crook, they've installed a 6-judge majority, and now they're using them as a political cudgel to try stealing not just a constitutional right, but an inherent human right from American women, the right to make their own reproductive decisions. By judicial fiat, the right-wing judges have decreed that the state will make birth decisions regardless of what mothers want. This is the Republican Party's current concept of small government. When the Supremes issued their government decree in June, headlines blared that the decision by, quote, conservatives on the court, quote, ends a woman's right to choose. That's wrong on 2 counts. First, there is nothing conservative about what amounts to a naked power grab by a small minority of pious ideological tyrants. Second, a human right cannot be ended. The judicial authoritarians who are perverting the court's purpose from justice to autocracy are deluding themselves if they think that 6 unelected judges ensconced in a marble bubble in Washington can deter the democratic imperative, much less the maternal authority, of millions of American women. Reality has many ways to conquer ideology. To be blunt, the right wing lost this fight the moment it won the ruling. Unfortunately, even the Biden White House doesn't get the depth of the public's outrage and determination to restore this right into law. Asked about rising anger at his inaction, Biden dismissed the critics. "I'm the only president they got," he snapped. This is Jim Hightower saying Joe might want to reflect on the vibrant history of American democracy. If leaders don't lead, the people will, even if that means getting a new president. The Hightower Radio Lowdown is made possible by you lowdowners who subscribe to our monthly newsletter, The Hightower Lowdown. You know who you are. Thank you.
Welcome back. You're listening to Be Bold America on KSQD 90.7 FM. Many voices, one station. Listen globally online from the ksqd.org website. And we're speaking with Professor Margaret Russell, who specializes in civil procedure, constitutional law, and contemporary legal theory. Now, Professor Russell, one of the words that has been running around in my mind for quite a while is the word perverse. It just seems that what they're doing is a perversion of the law. And I went back and I looked up the definition, and it talks about contrary to what is right or good or wicked or depraved, marked by misinterpretation or distortion. And then I look at the individuals that have been appointed, such as Amy Coney Barrett, who's tied to a far-right religious cult that believes women should submit to husbands. And, it's the People of Praise cult, and it's very influenced by far-right fundamentalists and Pentecostal evangelicals. This is someone we have on our Supreme Court. What are your thoughts about the judges right now that are the majority?
Well, unfortunately, this is a battle that has been lost and will affect jurisprudence for a lifetime. I don't usually just say. I'm not saying give up. However, I should be very blunt in saying that not only the majority of the U.S. Supreme Court, but increasingly the majority of the lower federal courts, that the vacancies that were filled by Trump and the vacancies that were blocked under Obama, and now there are even fights for Biden's nominees, there's really a rightward tilt to the federal judiciary. And so what this means, I think, for now, and in terms of being bold and doing something, is to continue to pay attention to what's happening with these nominations to the federal court and eventually the U.S. Supreme Court, but to pay a lot of attention to state courts, because rights are going to have to be vindicated at the state level that have been foreclosed at the federal level. And in some states, as we know, those with abortion bans and trigger laws, that's a pretty dire prospect.
Before I hand it over to Pettis, my program director and I had a lively conversation a couple of days ago, and looking at this, and would this decision be? Could we phrase it as that it's government forced birth in these states?
You mean to overturn this decision or to challenge it?
No, I meant this decision that it's made, that they've now created governmentally forced birth with no exceptions for rape and incest.
Yeah, that's certainly how I see it. I thought you were asking, so is this an argument that could be made? I certainly, and many other people, see it as just that. When Ruth Bader Ginsburg was in her pre-judge years, she talked about seeing the right to choose, not so much as the right to privacy under Roe, but she saw it as a right of liberty, that essentially it is involuntary servitude to have a woman carry a baby to term if that is not her choice. So I think that's exactly what's happening.
Right, and I guess if they move on to banning the ability to contraception, then that could be looked at as governmentally forced pregnancy then because you can't protect yourself. And yet this is the same group that talks about freedom and liberty,
right?
And small government, and yet now we have government forced birth. Pettis?
Absolutely.
Thanks. I think I want to go in the corner and cry right about now.
I thought I would cry hearing this.
Yes.
Well, I thought I would do it for you.
Oh, thank you, Pettis.
We've been talking about the impact to women, but not really to families and to boys and men. Obviously things that impact women in a way that the latest Supreme Court decisions have done have collateral damage, if you will, on everybody that surrounds those individuals. And it's going to change, and I think in some unfortunate, dire ways, how people function. If somebody's intent on getting an abortion, they're going to get an abortion. So do we go back to the back alley, abortion system? Do they, have to travel to some place where they can get it? Are there implications when they return home for having had an abortion? These things are Orwellian, to say the least. And I think they're putting us in a position where we're really going to be ratcheting up the things that are happening between families and within families as we go forward. But what do you say to the men and the boys, or what are the implications now for men and for women in light of these decisions? Do men become omnipotent? Do boys have the right to go around rape and just take what they want?
Well, of course not, but it is dire, and I guess what I would encourage, my kids are grown up, but in raising kids and in teaching or any young people that you're around is really to encourage them to be part of the pro-choice movement. If anything, I think this Dobbs decision did not settle the question, in the sense that many people in the public are unhappy, and I hear abortion discussed in a way that I really didn't hear earlier in my life. People, when I was growing up, people didn't say, "Oh, I had an abortion, and this is what happened." But now, I think there is this broader dialogue of just how personal a human right it is, and so I think boys and men certainly would do well to think about that and to ask themselves, if men could get pregnant, or that is, non-transgender men could get pregnant, is this the way that the law would treat men? I think the answer is no. Men's choices would be treated very differently.
Right. And, I'm glad that Pettis brought this up about messaging to boys, and the message back to Alito's decision, where really using the witch hunter of 16th, 15th century, whatever, as a message that you women have no power, is a message that I'm very concerned about, that's going to be sent to men. And I think it's already starting with certain men, because Matt Gaetz said recently that women who are protesting, that they're so ugly no one would want to impregnate them. What a vile, disrespectful thing to say. And then J.D. Vance recently said women in violent marriages should not get divorced.
Oh,
I mean,
goodness. Right.
This is property thinking again, that the woman is, and the disrespect. And so we're not talking about a woman's right to choose. We're talking about women being thought of as worse than second-class citizens, that they could speak to us and about us like that.
Those comments
this is another perversion.
Right. They're anti-woman in a way that I thought, we had sort of progressed from those attitudes decades ago. And to think that people who are elected actually say that, or people running for office say that, it means that they know that it will appeal to a certain audience of voters.
It's just shocking, and I don't think I've come out of it.
Decision
came down. I'm still in a state of shock.
We have to get ourselves to the ballot box. We have to try to ensure that people in states where the right to vote is being watered down and taken away, we have to make sure that we really change the people in office. It's unacceptable.
Yes, and I think in the couple of minutes before our break, I did want to share, and this is a party versus party issue. I mean, Republicans back in 1974, I have a list here. 1974, Republicans voted against the Equal Credit Act. 1978, Republicans voted against the Pregnancy Act that would have made the practice of firing women who became pregnant illegal. In 1980, Republicans voted against the bill that would have allowed women to report sexual harassment in the workplace. In 1994, Republicans voted against Violence Against Women Act. 2012, Republicans voted as a bloc against equal pay for equal work for women. In 2012, Republicans voted against the reauthorization of the Violence Against Women Act. And then now in 2022, we see what's happening with the Supreme Court. So this has been a long, the message that Republicans have consistently given is that women just shouldn't have any rights. It's just shocking. And it's come really, in my mind, come to fruition with this decision. We have a minute before your thoughts on what I just read, Professor.
Yes, I was thinking everything you said is true, and what makes it even worse is that these legislators are affirmatively advancing bills that discriminate. It's just not that they're voting no on progressive bills, but they are advocating anti-trans decisions on the state level. They're saying that teaching about race should be outlawed because critical race theory is taking over. So they're really on the offense as well as the defense in terms of progress.
Oh my! If you are just joining us, we're speaking with Santa Clara University School of Law Professor Margaret Russell. I'm your host, Jill Cody.
Today in America, one's political party is often tied to one's position on abortion. That was not always the case. During the 1950s and into the 1970s, Republicans often supported abortion as a matter of individual conscience and a form of family planning, especially in developing countries, but in the United States too. And they were allies of many environmentalists who were worried about the so-called population explosion. Next Sunday on KSQD's Sustainability Now, join Ronnie Lipschitz for a conversation with Dr. Carolyn Tracy, whose June 9th essay recounted the historical relationship between Republicans, environmentalism, and abortion. We'll also talk about the Reverend Malthus, his 18th century essay on population, and how it continues to affect political discourse today. That's on Sustainability Now, Sunday, August 7th from 5 to 6 p.m., right here on KSQD 90.7 FM and ksqd.org.
Be Bold America is available as a podcast. Now you and your friends may listen from your favorite podcast platforms such as Apple, Google, Spotify, Radio Public, and many more. Subscribe for free. Professor Russell, in these last few minutes, we like to ask our guests what we can keep doing, stop doing, and start doing. But I do know, before we get to that, I do know that Pettis has a question that he really wanted to ask you. Pettis?
Oh, absolutely.
Thank you. Thank you, Jill. Yeah, Professor, I was reading some of your background, and in 1991, you traveled to South Africa with a delegation of legal scholars to provide consultation on the drafting of their constitution for the post-apartheid transition. And I'm just wondering, when you juxtapose what you learned from that experience in South Africa and you look at the U.S. today, do you see any commonalities or any lessons that we can take at this critical juncture of our history to keep the country moving forward rather than falling backwards, which is the direction that some people are trying to push us?
Yes, and I think back to that trip with actually a certain kind of wistfulness or sadness, because the people there who were inviting U.S. scholars to come and talk about the U.S. Constitution said, well, your Constitution is really held up as, you know, a shining light of democracy and an example, and please, you know, present papers on how you think we can learn from you. They may have been surprised that most of the papers that we presented were critical of aspects of our Constitution, because they have not been enough, given, you know, the bias of courts, et cetera, and the regressive laws that are passed. They haven't been enough. And an example that I actually would give now is the fact that gender is not, equal rights for women is not in the Constitution, or it's rooted in history and tradition. That's through judicial interpretation. And so we advocated, and I still would, that the Equal Rights Amendment certainly needs to be ratified and become part of the U.S. Constitution. Concepts such as reparations or affirmative action, that's not in the U.S. Constitution. It would be very controversial to make it so. But without that, look where we are. I mean, I don't think we've made a lot of progress. So I think that our Constitution can be a tool of great freedom and equality. I think that right now it is not.
Thank you for that.
Yeah, I guess it just depends on whose hands our Constitution is in at the time. You know, who's in elected power. Yeah, well, Professor, what ideas might you have for us that we could keep doing, stop doing, start doing with this topic? I'm feeling a little bit hopeless, but maybe there's something we can keep at it.
Well, and I'd love to hear some of your thoughts on this too. But I was thinking, apropos of your hopelessness, that one thing that I think we should stop doing is thinking all is lost. And I say this as someone who has really struggled with this over the last couple of months, because of the January 6th hearings and what they have revealed, and because of the Supreme Court. There are many moments that I thought this, and climate change, I thought, this, what can we do? This is hopeless. But that's not true. It's just a very, very difficult period. And we are going to have to be, twice as diligent and committed, and I think twice as composed and willing to explain why our positions are important to other people. So I would say, to paraphrase the old saying, don't mourn, organize. I would say, okay, we've mourned. Now let's really organize. Let's not just continue with the mourning. As far as things to start doing, I mentioned that the federal bench and the U.S. Supreme Court and the state of federal law is such that we really have to look for different avenues to recognize people's rights and to restore them. And I would say that's especially true with regard to the right to vote, which sort of before our eyes is being, stolen away on a state level. I think that we really have to start focusing more on supporting people in states who desperately need progress on the state level in elections, in voter access to the ballot. That's going to be really important. And then things to keep doing. Well, we talked a little bit about what might be coming down the pike with regard to what Clarence Thomas mentioned. There may be other rights at stake. And certainly there are other areas that have come up, and there are cases that the Supreme Court has accepted for the next term in affirmative action, in anti-gay discrimination, and I think we have to keep on focusing on that and paying attention because there's much more to come of a difficult nature.
Well, I could not agree more. I think what I might add is something that I remember Dr. Ruth Ben-Gayat has said. We were honored to have her on our program twice, and she's an expert in fascism and authoritarianism. And she said Chapter 1, the authoritarian's playbook, is to suppress women. And I think what we have to keep aware of and start realizing is that we have a growing authoritarian movement in this country. And another thing that she said is that in authoritarianism is that psychological despair is a strategy. The onslaught of all these things that gives, I've had probably the same emotional ups and downs as you have had, Professor. It's been quite a roller coaster, and so this psychological despair happens, but then that just plays into the authoritarian strategy when we start getting into that despair, and we have to really deal with self-care, recharge our batteries, but not give up. They want apathy. They want you to give up. That plays right into it. And so Chapter 1 is suppressing women, and probably another chapter is this psychological onslaught that they want to project on society. What are your thoughts on that?
Do you mean me or Pettis?
Yeah, no, you, Professor. Yeah.
Oh, okay. I do think that those tools of suppression, it's sort of a playbook, and particularly because this has been such a rough year of feeling discouraged, of feeling okay, the courts are not a door to equality or freedom. That door is closed. It's hard to be encouraged, but I think what I'm saying now is not so much, let's stay hopeful, which was sort of a younger me. I'm just focusing on resilience. I'm saying, look, you don't have to smile and come to the table and say, everything's going to be fine, but let's be resilient and support each other.
Yes. We've got to be resilient, support each other. Pettis, we've just got maybe 1 minute till we need to wrap up. Did you have something quick you wanted to say in the Keep, Stop, Start?
Sure. I really think that these are opportunities that are in front of us. The fact that people are upset about the Dobbs decision, I think, is a good thing in the sense that people are angry and they're motivated to bring about some change. But as you and I, Jill, before the show talked, I really think that we need to start changing the narrative. We keep responding to the narrative of the right. And I think that we need to have them begin to respond to our narrative. In football, they talk about sometimes, the best offense or the best defense is a great offense. And I think that that's true. Because when you're in a defensive position, you're always in a reactive mode. And until we, as you and I, Jill, spoke about, and Professor, if we can shift the narrative from these fragmented ways of looking at the world to one that is much more comprehensive, like discrimination, rather than racism or supremacy, as opposed to some other functional thing that that we're chasing. I think we could do better. We need to get on the offense on this thing and really
I wish we had
stop this.
I wish we had more time. Oh gosh. Sorry to interrupt you there, Pettis.
That's okay.
The clock is doing it.
That's okay.
Oh, thank you. Professor Russell, Pettis and I are so grateful you joined us on Be Bold America. Thank you for explaining to us the world in which women are now living. It is astounding and surreal to me.
Thank you very much.
Yeah, keep doing your good work there, Professor.
Yes, keep doing your good work. We must all understand this new world to make the change that we're talking about. Our future depends on it. Thank you, Professor Russell.
Yes,
take care.
Thank you, too. Good luck. Bye-bye.
Bye-bye.
Bye. What's next on Be Bold America on August 14th at 5 p.m.? We will be speaking with Pedro Hernandez from the California Office of Common Cause. What is Common Cause? They are a watchdog group based in Washington, D.C., founded in 1970 by a Republican. Their initial fights were bringing about an end to the Vietnam War and to lower the voting age to 18. But today they're fighting for Americans to understand the decisive new evidence brought forth by the January 6th Select Committee. And we are only 7 states away from a disastrous Article 5 constitutional convention and to fight the oldest electoral trick in the book, disinformation. That will be on Be Bold America, August 14th at 5 p.m. Remember, Be Bold America is available as a podcast now. You may listen to the show anytime for free, wherever you get your podcasts. I want to give a special thank you to Be Bold America's program engineer, Eliza James, and the station's program director, Howard Feldstein. And again, to our bold friend, Professor Margaret Russell from the Santa Clara University School of Law. You're listening to KSQD Santa Cruz, many voices, one station. Listen worldwide online at ksqd.org. My name is Jill Cody.
And I'm Dr. Pettis Perry.
And thank you for listening to Be Bold America. Until next time, keep, stop, start.